Before we begin, a quick and important disclaimer. The following presentation delves into complex historical media analysis and the evolution of family law within the United States. The content provided in this video is strictly for educational and entertainment purposes only and absolutely does not constitute professional, legal, or financial advice. We will be analyzing historical trends, legal paradigm shifts, and specific case studies regarding marital dissolution and media consumption. Every individual's legal situation is entirely unique, and you must conduct your own due diligence and consult with licensed legal professionals or qualified legal document assistants in your specific jurisdiction before making any decisions regarding family law, asset division, or marital status. Imagine sitting in a dimly lit parlor in 1932, the heavy wooden casing of a Zenith radio glowing softly in the corner, projecting a voice that would fundamentally alter the American psychological landscape forever. The voice belonged to a fictional character, but the tears, the betrayals, and the domestic catastrophes felt overwhelmingly real to the millions of listeners tuned in across the country. In the span of just a few years, corporate sponsors, primarily detergent manufacturers like Procter & Gamble, realized that the most effective way to sell household products to women was to weaponize their deepest domestic anxieties. They invented a genre of serialized audio storytelling designed to manufacture endless, agonizing relationship conflict. We call them soap operas today, but in the golden age of radio, these broadcasts were the architect of the modern American romantic expectation. They taught a generation that domestic life was supposed to be a high-stakes, emotionally volatile theater. Now fast forward to the present day, to a small brightly lit office strip in the 661 area code of California. Here, the dissolution of a marriage, the exact subject matter that fueled decades of sensational radio broadcasting, is reduced to a quiet, hyper-efficient, flat-fee administrative transaction. No screaming matches, no shocking reveals, no dramatic cliffhangers before a commercial break. Just a meticulously organized stack of court forms handled by a legal document assistant. How did the American experience of marriage and separation transition from the breathless, serialized melodrama of the 1930s radio waves to the clinical, unbundled legal reality represented by modern procedural services like those famously operating out of the Santa Clarita Valley? We are about to dissect the massive, hidden sociological whiplash that has completely rewired the American family. We will uncover how broadcast media corporations intentionally condition society to view relationships as theatrical commodities, and how the legal system ruthlessly pivoted in the exact opposite direction, stripping away every ounce of drama to create a sterile, bureaucratic machinery of uncoupling. If you have ever wondered why the reality of modern relationships feels so deeply disconnected from the cultural narratives we are fed, the answer lies in the forgotten history of AM radio and the quiet revolution of legal procedure. To understand the magnitude of this shift, we must first analyze the historical trends of the American radio drama and its insidious, brilliant construction. In the early 1930s, the American public was reeling from the catastrophic economic collapse of the Great Depression. The outside world was a terrifying, uncontrollable environment defined by poverty and instability. Radio networks, specifically in Chicago, which served as the early epicenter of broadcast drama, recognized an unprecedented opportunity. Pioneers of the medium, most notably a former schoolteacher named Erna Phillips, conceptualized a format that brought the drama indoors. Phillips created programs like Painted Dreams and later The Guiding Light, which pioneered the 15-minute serialized daytime drama. These programs were meticulously engineered to focus almost entirely on interpersonal conflict, marital strife, infidelity, and complex family power dynamics. The brilliance of the radio drama was its intimacy. Unlike a film viewed in a crowded theater, the radio voice spoke directly into the living room, often to a primary audience of homemakers who were isolated in their daily routines. The dramatic structure relied on the open loop, the daily cliffhanger that forced the listener to tune in the next day to find out if the marriage would survive the latest fabricated catastrophe. This wasn't just entertainment, it was a form of psychological conditioning. These broadcasts, sponsored heavily by corporations eager to sell soap and cleaning supplies to this exact demographic, created a feedback loop of domestic anxiety. They established a baseline cultural expectation that marriage was inherently dramatic, fraught with deception, and constantly teetering on the edge of spectacular ruin. When couples fought in the 1940s and 1950s, they increasingly mapped their own behaviors onto the dramatic archetypes they heard echoing from their Philco and Motorola speakers every afternoon. However, while the media was busy maximizing the theatricality of domestic breakdown, The American legal system was slowly buckling under the weight of actual, real-world marital failure. During the peak years of radio drama, obtaining a divorce in the United States was a grueling, highly restricted, and intensely adversarial process. It was rooted in the concept of fault. To legally end a marriage, one party had to publicly accuse the other of a specific, legally recognized transgression, such as extreme cruelty, adultery, or abandonment. This legal framework inadvertently mirrored the radio dramas. It forced couples to become plaintiffs and defendants in a literal courtroom drama, complete with witness testimony, public accusations, and dramatic reveals. The system was so restrictive that it spawned entirely new industries, such as the infamous divorce mills of Reno, Nevada, where wealthy individuals would temporarily relocate just to utilize slightly more permissive state laws, turning their legal maneuvers into national tabloid spectacles. But this theatrical approach to the law was ultimately unsustainable. The turning point, which initiated the stark contrast we see today, occurred exactly 54 years ago in California. In 1969, Governor Ronald Reagan signed the Family Law Act, making California the very first state in the Western world to institute no-fault divorce. This single legislative stroke fundamentally altered the trajectory of the American family. It declared that a marriage could be dissolved simply due to irreconcilable differences. No accusations were necessary. No dramatic courtroom testimony was required to prove infidelity. The state effectively decided that the emotional narrative of the breakup was legally irrelevant. This brings us to the modern paradigm, perfectly encapsulated by the phenomenon of the unbundled legal service model, heavily populated in regions like the 661 area code of northern Los Angeles County. Today, the cultural expectation of the dramatic split is met with the crushing bureaucratic reality of the modern court system. The sheer cost of adversarial litigation has driven a massive sector of the population away from traditional attorney representation. Instead, we see the rise of the legal document assistant, or LDA. Services operating under the colloquial banner of Divorce 661 represent the ultimate antithesis of the radio drama. They do not represent clients in court. They do not argue over the emotional weight of a betrayal. They operate strictly within the realm of procedure, processing the intricate, heavily coded forms required by the state. This series will serve as a comprehensive masterclass, unraveling this massive societal contradiction. You will learn the specific, calculated techniques used by early broadcasters to monetize relationship anxiety, creating an emotional blueprint that still influences television and social media today. We will analyze the historical case studies that forced the legal system to abandon the fault-based courtroom dramas of the past. Finally, we will provide an exhaustive step-by-step breakdown of how the modern alternative dispute resolution industry actually functions, empowering you to understand the stark difference between the media's portrayal of conflict and the actual procedural reality of navigating the modern legal landscape. This knowledge is not just history. It is a vital tool for understanding the mechanisms that govern our most private lives. To truly grasp the scale of this psychological conditioning, we must step inside the laboratories where this domestic anxiety was manufactured. Imagine if your entire understanding of romantic conflict was dictated by a detergent company trying to sell you laundry powder. That is not a metaphor. In the late 1930s, advertising executives working for conglomerates like Procter & Gamble and Lever Brothers realized that simply reading copy about soap was profoundly ineffective. They needed a vehicle. They needed to hijack the emotional bandwidth of the American homemaker. Enter the Hummert radio factory. Frank and Hummert were arguably the most prolific producers of early radio dramas, creating a staggering production line of emotional turmoil. They did not view themselves as artists. They were behavioral engineers. They stripped away all the nuance of human interaction and replaced it with a highly rigid, ruthlessly effective formula. Every single episode of shows like The Romance of Helen Trent or Ma Perkins was strictly engineered to agitate the listener. Writers utilized a technique known as agonizing pacing. A single conversation about a potentially unfaithful husband could be stretched across 3 weeks of 15-minute broadcasts. This was not a flaw in the writing. It was the entire point. By maintaining a constant, low-grade sense of dread, the Hummerts ensured that the listener remained in a state of suspended emotional animation, perfectly primed to absorb the commercial messaging inserted at the beginning, middle, and end of the broadcast. You have to understand the historical trends of media consumption here. By 1940, over half of all American women who were at home during the day were listening to these serials. That is an audience of tens of millions, tuning in 5 days a week, 52 weeks a year. absorbing the core narrative that marriage is an inherently unstable, deeply deceptive institution where ruin is always just one commercial break away. This sustained exposure created a profound cultural blueprint. The drama of the radio waves established a baseline expectation for the American public. People began to unconsciously perform the conflict they heard on the radio. The intense, accusatory dialogue, the sudden betrayals, the dramatic exits. These fictional constructs bled into the reality of mid-century American kitchens and living rooms. The media had successfully commodified marital strife, turning the breakdown of a relationship into a highly profitable spectator sport. And for decades, the American legal system was perfectly aligned with this theatricality. As we briefly touched upon, the fault-based divorce system required exactly the kind of performative conflict that radio had trained the public to expect. You had to prove your spouse was a villain to be granted your freedom. But let us violently pull that historical thread into the present day. We are currently in the year 2026. The legacy of that early radio conditioning still completely saturates our reality television, our streaming platforms, and our social media algorithms. We are still addicted to the spectacle of a messy breakup. However, the actual mechanical process of dismantling a marriage has moved entirely in the opposite direction, creating a massive cognitive dissonance for anyone actually going through it today. Let us look at a modern case study unfolding right now in the 661 area code. The sprawling suburban landscape of Santa Clarita, California. Meet David and Jessica. They have been married for 8 years, they own a home, they have 2 cars, and they have decided to separate. Based on the century of media programming they have consumed, David and Jessica unconsciously expect a battle. They expect tense mediations, sudden legal maneuvers, and a judge banging a gavel while their respective attorneys deliver impassioned speeches. They expect the drama. Instead, they discover the absolute clinical reality of the modern unbundled legal service model. They walk into a small, unassuming office nestled between a dental clinic and a tax preparation service. They sit across from a legal document assistant, not a high-powered litigator. There is no mahogany desk, no leather-bound law books lining the walls, and absolutely no opportunity for them to air their emotional grievances. The legal document assistant does not care who stopped trying, who is unfaithful, or who is to blame for the collapse of the union. Their entire operational model is based on stripping the emotion out of the equation and reducing David and Jessica's 8-year history into a series of standardized alphanumeric forms mandated by the state of California. Form FL 100, the petition for dissolution. Form FL 140.1, the declaration of disclosure. The process is shockingly sterile. The historical trends of family law have shifted so radically toward administrative efficiency that the very concept of fault has been eradicated from the paperwork. David and Jessica are simply required to list their assets, assign a monetary value to their shared property, and agree on a mathematically equitable division of those assets based on state community property guidelines. This is the profound reality of Divorce 661 and thousands of similar services operating across the United States today. They are processing relationship endpoints with the same dispassionate efficiency as the Department of Motor Vehicles processing a vehicle registration renewal. The entire transaction is conducted via secure online portals, electronic signatures, and notarized document uploads. There is no court appearance. There is no public testimony. For a flat, transparent fee, the bureaucratic machinery quietly dissolves the legal bond, leaving David and Jessica legally separated, but often deeply bewildered by the sheer lack of friction. They are left holding a manila envelope of finalized court orders, wondering where the climax of their story went. This vast gulf between the high-stakes, emotionally volatile breakups we are conditioned to expect by the descendants of early radio drama, and the flat, transactional reality of modern procedural uncoupling, is one of the most fascinating cultural paradoxes of our time. We have built a society that obsessively consumes relationship trauma as entertainment, yet we have simultaneously engineered a legal system that completely refuses to acknowledge that trauma exists. But how exactly did the legal system pull off this monumental pivot? How did we transition from a society that demanded public, humiliating proof of marital failure in a crowded courtroom, to a society that allows you to end a marriage via a digital signature from your smartphone while waiting in line for coffee? The answer involves a massive, highly coordinated legal rebellion, a profound shift in sociological data, and a controversial legislative battle that completely redefined the concept of personal freedom in America. The mechanics of that revolution are hiding in plain sight, and understanding them will change everything you thought you knew about the law. To understand the mechanics of this legal revolution, you must first understand the sheer, absolute absurdity of the system that preceded it. Imagine if right now, in the year 2026, ending your marriage required you to hire a professional photographer, rent a cheap motel room, and pay a complete stranger to pose in an inherently compromising position just so a judge would grant you the legal right to live alone. This is not a bizarre hypothetical scenario. This was standard operating procedure for thousands of American couples navigating the fault-based divorce system during the exact same era when radio dramas were at their peak. States like New York possessed incredibly restrictive legal frameworks where the absolute only acceptable ground for the dissolution of a marriage was adultery. The state fundamentally refused to acknowledge that two human beings might simply grow apart, become incompatible, or suffer from irreconcilable differences. The law demanded a villain. It demanded a severe moral transgression. Therefore, if a couple mutually agreed that their marriage was over, they were forced into a bizarre, highly choreographed legal pantomime known as the collusive divorce. This collusive perjury became a thriving, albeit shadowy, sub-industry. A husband would coordinate with his own wife and their respective attorneys to stage an act of infidelity. He would check into a designated hotel. A woman, often referred to in the industry as a professional correspondent, would arrive at a predetermined time. She would remove her coat, perhaps sit on the edge of the bed, and then a hired private investigator and a photographer would burst through the door to document the supposedly shocking scene. This meticulously fabricated evidence would then be presented in a court of law. The judge presiding over the case usually knew the evidence was completely staged. The attorneys presenting the evidence absolutely knew it was staged. The husband and wife obviously knew it was staged. Yet, the entire courtroom engaged in this collective theatrical performance because the rigidity of the legal system offered no other escape hatch. It was a systemic mockery of justice, a performative trauma engineered to satisfy archaic legal statutes. If you had financial resources, you could bypass the hotel room charade and participate in another massive historical trend of the era, the migratory divorce. Imagine a woman named Eleanor in 1955. She wants a divorce, but her home state laws make it nearly impossible. Instead of staging an affair, Eleanor boards a train and travels across the country to Reno, Nevada. Nevada had intentionally engineered its state laws to require only a 6-week residency to grant a divorce, capitalizing on the restrictive laws of other states. Eleanor would check into a specialized divorce ranch, an entire hospitality sector built exclusively around wealthy individuals waiting out their 42-day legal purgatory. She would spend her weeks riding horses, playing cards, and waiting for the local courts to rubber stamp her paperwork. Upon receiving her decree at the Washoe County Courthouse, the tradition was to walk directly to the Virginia Street Bridge and toss her wedding ring into the Truckee River. This was the reality of family law. It was either a staged, localized lie or an expensive cross-country vacation. Contrast this reality with what the American public was consuming on the radio. Broadcast producers like the Hummerts were terrifying the nation with stories of genuine betrayal, heart-wrenching emotional destruction, and families torn apart by spontaneous malice. The media was selling the absolute sincerity of marital tragedy, while the legal system was forcing couples to manufacture fake tragedies just to process basic administrative changes to their marital status. The dissonance was staggering. The American public was being trained to view divorce as an emotional apocalypse, while simultaneously navigating a legal reality that treated it like an underground theatrical production. The breaking point for this unsustainable legal theater occurred in California. By the early 1960s, the sociological data was becoming impossible to ignore. The post-war nuclear family model was under immense pressure. Society was evolving, women were slowly gaining more financial independence, and couples were increasingly unwilling to remain trapped in deeply unhappy marriages simply because they could not prove a specific legal fault. In 1963, the California legislature established a specialized commission to aggressively investigate the family law system. The findings of this commission were a devastating indictment of the status quo. They concluded that the fault-based system was completely ineffective at preserving marriages. Instead, it was actively generating immense hostility, wasting vital judicial resources, and essentially forcing the citizens of California to commit widespread perjury just to escape failed relationships. The commission proposed a radical, earth-shattering concept that completely de-weaponized the legal process. They suggested that the state should simply stop asking why a marriage failed. They introduced the concept of irreconcilable differences. This was the conceptual birth of the modern paradigm, the exact foundation that allows a modern 2026 couple, let us call them Michael and Sarah, to utilize a legal document assistant in the 661 area code. When Michael and Sarah walk into that unbundled legal service office in Santa Clarita today, they are the direct beneficiaries of that 1960s rebellion. Because of the concept of irreconcilable differences, they do not need a professional correspondent. They do not need to travel to a dude ranch in Nevada. They do not need to stand in front of a judge and hurl fabricated accusations at each other. The state of California no longer requires a villain to process their paperwork. The implementation of the Family Law Act in 1969 fundamentally transformed the dissolution of marriage from a moral judgment into an administrative procedure. It paved the way for the flat-fee document preparation industry that thrives today by stripping away the mandatory courtroom drama. It aligned the legal process with the reality of human relationships, acknowledging that sometimes partnerships simply end without a spectacular, radio drama-worthy betrayal. The legislative intent was to sanitize the process, reduce the emotional carnage, and make the legal system more honest. However, whenever you execute a massive systemic change to a societal foundation, the historical trends show that the ripple effects are rarely predictable. While the creators of the no-fault divorce system successfully eradicated the perjury mills and the forced theatricality of the courtroom, they inadvertently triggered a completely different kind of crisis. By stripping away the concept of legal fault, they accidentally stripped away the single most powerful point of financial leverage that vulnerable spouses, primarily women who had dedicated their lives to domestic labor, had relied upon for decades to secure their economic survival post-divorce. The transition from dramatic courtroom battles to sterile bureaucratic paperwork unleashed a terrifying economic reality that the legislature entirely failed to anticipate. And exactly how this well-intentioned law violently backfired, plunging thousands into immediate poverty and forcing yet another massive, desperate evolution in how the state handles the division of assets and spousal support, is a dark, complex chapter that completely altered the trajectory of American wealth distribution. To comprehend the catastrophic financial shockwave triggered by the removal of legal fault, you must first understand the invisible power dynamics of a mid-century marriage. Prior to 1969, the strict requirement of proving fault acted as a massive, unintended financial shield for the economically disadvantaged spouse. Imagine a historical scenario taking place in 1958. A primary breadwinning husband wishes to abandon his family to pursue a relationship with a different woman. Because his home state requires a legally recognized moral transgression to grant a divorce, and because he is the party who wishes to terminate the contract, his wife holds absolute legal veto power over his future. If she refuses to participate in a staged collusive perjury, or simply denies him the divorce altogether, he remains legally and financially bound to her indefinitely. This systemic bottleneck gave the non-working spouse extraordinary negotiating leverage. She could sit across a mahogany table from his attorney and state unequivocally that she would only agree to the dissolution if she retained the family home, received half of his pension, and secured an exorbitant monthly alimony payment. She was essentially bartering her legal consent in exchange for her lifelong financial security. It was a brutal and coercive framework, but it inadvertently prevented the state from having to financially support abandoned, destitute families. When the state of California implemented no-fault divorce, they completely vaporized this leverage overnight. The legislative intent was noble. They wanted to stop widespread courtroom perjury and sanitize the legal system. But the immediate real-world outcome was an economic bloodbath for a specific demographic. Without the need for mutual consent, a primary wage earner could simply file a petition citing irreconcilable differences, wait out the mandatory 6-month cooling-off period, and walk away. The courts, initially operating under outdated, patriarchal assumptions that separated women would quickly remarry, frequently awarded minimal, short-term spousal support. Judges routinely forced the immediate sale of the family home to divide the cash equity, leaving mothers scrambling for housing. Historical trends from the 1970s document a massive, terrifying spike in the poverty rates among middle-aged, newly single women. Sociologists coined a sobering term for this rapidly expanding demographic: the displaced homemaker. These were human beings who had invested decades of unpaid domestic labor into a marital enterprise, completely adhering to the societal expectations broadcasted to them via radio dramas and television, only to find themselves unilaterally discarded by a legal system that suddenly prioritized administrative efficiency over their economic survival. This sudden influx of impoverished citizens completely overwhelmed local municipalities and state welfare programs. The legal system realized it had engineered a sociological disaster and had to desperately pivot to plug the financial hemorrhage. If they could no longer use moral fault to strong-arm wealthy spouses into paying exorbitant settlements, they had to rely on cold, unforgiving mathematics. The courts radically strengthened and formalized the application of community property laws. The new paradigm declared that marriage was not a romantic union, but a strict, relentless economic partnership. Any income earned, any property acquired, and any retirement account funded from the exact date of the wedding to the exact date of separation was suddenly classified as a joint asset. This meant it belonged equally to both partners, regardless of whose name was printed on the paycheck or recorded on the property deed. Fast forward to the current year, 2026, and observe how this strict mathematical framework completely governs modern unbundled legal services in regions like the 661 area code. Let us examine a modern case study involving a couple named Richard and Amanda, living in a suburban neighborhood in Valencia, California. Richard has committed a massive, undeniable betrayal. He has drained a secret savings account, maintained a double life for over a year, and utterly shattered the emotional foundation of their 10-year marriage. Amanda is devastated, based on every single narrative trope she has ever absorbed from media, tracing all the way back to the agonizing pacing of the Hummert radio factories and culminating in modern reality television. She expects vengeance. She unconsciously expects the legal system to aggressively punish Richard for his moral failure. She expects a judge to look at his reprehensible actions and award her the entirety of their shared estate as direct compensation for her trauma. When Amanda consults with a legal document assistant to process her paperwork, the cognitive dissonance she experiences is staggering. The procedural reality of the California family law system dictates that Richard's betrayal is entirely irrelevant to the division of their assets. The state absolutely does not punish bad behavior with community property. The home they purchase together will be appraised, and the equity will be split strictly down the middle. Richard's retirement accounts, accumulated over the last decade, will be divided mathematically via a qualified domestic relations order. There is absolutely no emotional premium paid for infidelity. The legal document assistant will simply input their mandatory financial disclosures into a standardized state matrix, treating the dissolution of their deeply troubled marriage with the exact same emotional detachment as a corporate liquidation. The absolute apex of this sterile mathematical approach is found in the modern calculation of spousal support. In the era of the radio drama, alimony was an emotional weapon deployed in the courtroom. Today, in jurisdictions utilizing unbundled administrative services, it is an algorithm. Legal professionals and document assistants utilize highly specific software programs to determine the exact flow of capital between separated spouses. This software requires rigid numerical inputs such as gross monthly income, tax filing status, mandatory union dues, health insurance premiums, and the precise mathematical percentage of time each parent spends physically supervising the children. The program cross-references these data points with complex federal and state tax brackets and instantly generates a precise monthly dollar amount. The algorithm does not care who cried, who lied, or who broke the sacred vows. Its only function is to equalize the tax burden and stabilize the net disposable income across two entirely separate households. This algorithmic efficiency is exactly what allows administrative services operating under the Divorce 661 model to thrive in the modern era. By completely ignoring the emotional wreckage and refusing to litigate fault, they can process a marital dissolution for a flat, transparent fee of a few $100s instead of the tens of thousands required to fund a traditional, adversarial litigation campaign. The state successfully solved its welfare crisis by turning marriage into an emotionless spreadsheet, and the unbundled legal industry democratized public access to that exact spreadsheet. But this extreme pendulum swing from the theatricality of the fault-based system to the clinical mathematics of modern procedure created a massive, unforeseen psychological vacuum. The American public, still deeply conditioned by a century of broadcast media to require dramatic closure, suddenly found a legal system that flatly refused to provide it. And when the courts stopped validating the emotional trauma of a breakup, a deeply predatory, highly lucrative shadow industry quietly rose up to fill that void, specifically designed to monetize the psychological wreckage that the state deliberately abandoned. This shadow industry is not an illegal cartel operating in back alleys. It is the perfectly legal, deeply entrenched, and incredibly lucrative adversarial family law litigation complex. When the state governments, beginning with California, stripped the concept of moral fault from the legal processing of marital dissolution, They created a massive psychological vacuum. We must remember the historical trends discussed earlier. The American public had been subjected to decades of intense cultural conditioning, beginning with the highly engineered radio soap operas of the 1930s. They were trained to believe that the end of a romantic partnership must inherently feature a clear protagonist, a definitive antagonist, and a public reckoning where the wrongdoer is punished. The unbundled, flat-fee administrative services operating out of strip malls in the 661 area code offer none of this. They offer sterile mathematical equations and algorithmic support calculations. But human beings navigating the terrifying emotional landscape of a shattered marriage rarely want a spreadsheet. They desperately want justice. They want validation. They want a stage. Enter the traditional high-conflict family law attorney. If the legal document assistant is the bureaucratic administrator of the modern era, the high-conflict litigator is the modern descendant of Frank and Hummert, the original architects of the radio drama. These legal professionals recognize the exact psychological vulnerability that the no-fault system created, and they built an entire economic model around monetizing that unfulfilled need for narrative closure. Their business model relies entirely on the billable hour, a financial mechanism that directly incentivizes the agonizing pacing we saw in early broadcast media. Just as the radio producers stretched a simple conversation over 3 weeks of episodes to keep the audience hooked and the soap sponsors happy, the adversarial litigation system stretches the basic division of assets over months or even years to maximize revenue. The conflict is the product. Let us examine a highly detailed case study set in the current year of 2026 to illustrate exactly how this psychological monetization functions. Imagine a couple named Christopher and Melissa, living in a relatively affluent suburb of Dallas, Texas. They have accumulated a typical upper-middle-class estate, a primary residence with significant equity, 2 fully funded 401k retirement accounts, a joint brokerage portfolio, and 2 children. Christopher has initiated the divorce after years of emotional disconnect, and Melissa is deeply wounded, feeling betrayed and entirely discarded. The flat-fee, unbundled route is readily available to them. A service could divide their estate mathematically in a matter of weeks. But Melissa's emotional state, conditioned by a lifetime of media consumption demanding a dramatic climax, rejects the sterile administrative option. She wants Christopher to understand the magnitude of his failure. She wants him to pay. She schedules an initial consultation with a prominent, aggressive family law litigator. This consultation is the critical hook. While the state court system absolutely refuses to listen to Melissa's emotional grievances, the litigator sits across a polished mahogany desk and does the exact opposite. The litigator listens intensely, validates her anger, and subtly reinforces the narrative that she is the victim of a profound injustice. The attorney does not promise a specific financial outcome, which would violate ethical guidelines, but they absolutely sell the potential outcomes of a relentless legal campaign. They sell the illusion of control and the promise of a fight. Melissa signs a retainer agreement, often depositing $25,000 to $50,000 into a trust account just to initiate the theater. Once the retainer is secured, the agonizing pacing begins through the weaponization of legal procedure. The primary tool in this manufactured drama is the discovery process. In an unbundled, mediated divorce, financial disclosures are voluntarily exchanged using standard state forms. In the adversarial shadow industry, discovery is a battleground. Melissa's attorney will issue massive, sprawling demands for the production of documents. They will demand a decade of bank statements, credit card receipts, business ledgers, and digital communications. They are not simply looking for assets. They are looking for a story. They are looking for a single unexplained restaurant charge from 3 years ago that can be spun into an accusation of hidden marital waste. Christopher, terrified by the aggressive legal posture, is forced to hire his own high-priced litigator to defend himself. The 2 legal teams now begin trading motions, counter-motions, and demands for protective orders. The actual estate of Christopher and Melissa is completely forgotten. The focus is now entirely on the conflict itself. To heighten the drama and increase the billable hours, the attorneys will cast a supporting ensemble of highly paid expert witnesses. They will hire forensic accountants at $500 an hour to trace the lineage of every dollar in the joint checking account. They will hire vocational experts to argue over Melissa's hypothetical earning capacity in the modern job market. If there is even a slight disagreement over the parenting schedule, they will inject a child custody evaluator into the family dynamic, subjecting the children to psychological testing and clinical observation to determine which parent is mathematically superior. This entire spectacle culminates in the deposition, the modern equivalent of the courtroom drama, entirely privatized and hidden from public view. Christopher will be forced to sit in a sterile conference room for 8 hours while Melissa's attorney meticulously dissects every failure of his 10-year marriage on the official record. A court reporter will transcribe every stutter, every defensive response, and every agonizing silence. This is the exact performative trauma the no-fault system was designed to eradicate, yet it has been entirely recreated and privatized for those who can afford the entry fee. The irony is staggering. The state mandated no-fault to save families from the emotional devastation of the collusive perjury mills. But the shadow industry simply moved the devastation out of the courthouse and into the private conference rooms of high-rise law firms. The ultimate tragedy of this highly engineered litigation drama is the billable hour ledger. Every single email, every phone call, every drafted motion, and every hour spent by the forensic accountant is meticulously recorded in 6-minute increments and billed against the initial retainers. The estate that Christopher and Melissa spent a decade building is slowly, methodically transferred to the legal professionals managing their conflict. They are funding their own destruction, driven by a culturally ingrained desire for a dramatic resolution that the legal system is structurally incapable of providing. But this engineered conflict is completely unsustainable. Eventually, the psychological theater collides violently with mathematical reality. There is a precise, devastating moment in almost every adversarial divorce case where the illusion shatters, the anger evaporates, and the crushing weight of the financial devastation finally takes hold. This phenomenon, heavily documented in recent historical trends of family law, acts as the ultimate circuit breaker for the litigation machine. It forces even the most combative spouses to abandon their crusade and desperately seek the exact unbundled, administrative off-ramps they initially rejected. Understanding the anatomy of this exact breaking point is crucial, because it reveals the dark psychological turning point where the desire for revenge is finally eclipsed by the absolute terror of impending bankruptcy. The anatomy of this exact breaking point is crucial, because it reveals the dark psychological turning point where the desire for revenge is finally eclipsed by the absolute terror of impending bankruptcy. This capitulation rarely happens in a courtroom in front of a judge. Historical trends indicate it almost always happens in the quiet, desperate isolation of a kitchen table late at night, usually around month 9 of the adversarial litigation process. It happens the exact moment the second or third retainer replenishment request arrives in the mail or the inbox. The initial $25,000, the money that was supposed to secure absolute victory and moral validation, is completely gone. It has been entirely consumed by endless emails, mandatory status conferences, and heavily contested discovery motions over trivial banking discrepancies. The psychological high of fighting back, the righteous indignation fueled by a lifetime of consuming dramatic media, is violently replaced by the sobering, inescapable reality of the balance sheet. Imagine if you are Melissa in the year 2026. You receive your monthly billing statement from your high-conflict family law attorney. The invoice is 14 pages long. You see a charge for $800, billed in relentless 6-minute increments, just for your attorney to read, analyze, and draft a response to a hostile email from Christopher's attorney regarding the division of living room furniture. You stare at the document and realize that your retirement account, the exact asset you are desperately fighting to protect, is being aggressively liquidated to fund the fight over the asset. The mathematics of vengeance no longer make any logical sense. The desire to punish your spouse, to have a judge publicly condemn his betrayal just like the dramatic climax of a 1940s radio serial, has been completely erased by the sheer terror of having to sell your family home, simply to pay the legal professionals managing your dispute. This is the critical juncture where the adversarial system collapses under its own manufactured weight. The entire litigation complex relies heavily on the illusion of a zero-sum game, a theatrical battle where one party can achieve total victory and the other suffers total defeat. But the state laws, especially in jurisdictions like California, operate on strict community property guidelines. Total victory is a fundamental legal impossibility. The state does not care about the emotional narrative. The attorneys know this undeniable fact from the very first consultation, but the client only discovers it after spending $50,000 to hear a judge hastily tell them what a legal document assistant would have told them for a flat fee on day one. Sell the house, split the equity, divide the pension mathematically, and move on. This psychological exhaustion forces a radical, necessary pivot. The high-powered litigators are either fired, or they voluntarily withdraw from the case the moment the cash flow stops. The warring spouses, now financially depleted, emotionally shattered, and terrified of their uncertain futures, are forced to collaborate out of sheer survival instinct. They find themselves frantically looking for the exact administrative off-ramp they initially scoffed at. They look toward the procedural efficiency of the unbundled legal model, the exact service architecture that defines operations like those thriving in the 661 area code. They realize that the legal system is not a theater for justice. It is an administrative processing center for asset reallocation. How does a couple successfully transition from thermonuclear litigation back to a peaceful, administrative settlement? It requires a profound psychological surrender. They must mutually agree to stop demanding a villain. When they finally walk into an unbundled legal service office, the legal document assistant steps in not as a warrior, but as a neutral project manager. The legal document assistant takes the chaotic, bloody battlefield of their half-finished litigation and surgically organizes it into the standardized, required state forms. They utilize forms like the FL-130, the appearance, stipulations, and waivers, which officially signals to the court that the parties are laying down their weapons and agreeing to proceed by mutual consent. Let us examine the precise mechanics of this surrender. The unbundled service requires them to sit down, often utilizing secure virtual portals common in the post-pandemic landscape of 2026, and simply agree on the math. There are no more forensic accountants billing hundreds of dollars an hour. There are no more aggressive, traumatizing depositions. If they have a joint brokerage account, they agree on a specific valuation date and divide the shares equally. If they have accumulated crippling credit card debt during the separation, they assign the balances to specific columns on a spreadsheet. The legal document assistant then carefully encodes this mutual agreement into a comprehensive marital settlement agreement. This is a highly detailed, legally binding contract that outlines every single term of their uncoupling, bypassing the courtroom entirely. The judge simply reviews the contract for basic legal compliance and signs the final judgment. This transition represents one of the most profound societal ironies of the modern American family. We begin the process burdened by a century of media-induced expectations, demanding a dramatic, radio drama conclusion to our broken relationships. We voluntarily surrender tens of thousands of dollars, attempting to purchase that dramatic climax from the deeply entrenched shadow industry of adversarial litigation. And we ultimately end up exhausted, nearly bankrupt, and quietly signing administrative paperwork, arriving at precisely the destination the modern, no-fault legal system intended for us all along. The broadcast media conditioned the public for war. The state legislature engineered a system for quiet peace, and the resulting friction between those two realities created a multi-billion-dollar legal economy fed by human heartbreak. However, this realization, this eventual surrender to the cold mathematical reality of asset division, is relatively straightforward when dealing with bank accounts, vehicles, and real estate. A house is a static physical asset. A retirement portfolio is a highly quantifiable string of numbers. You can divide them seamlessly on a spreadsheet. But there is one fundamental component of the American family that completely shatters this algorithmic approach. There is one specific area where the modern state desperately attempts to apply cold, hard mathematics and procedural efficiency to living, breathing human beings, and the potential outcomes are frequently catastrophic. What happens when the central dispute is not about who gets to keep the marital home, but who gets to keep the children? The modern unbundled legal system attempts to treat child custody with the exact same procedural efficiency as a joint tax return, utilizing rigid physical custody schedules and automated, algorithmic support calculators. But the hidden history of how the American legal system actually views children is deeply disturbing, evolving from treating them as literal agricultural property in the 19th century to weaponizing them as leverage in modern psychological warfare. The massive transition from the emotional radio era to the modern bureaucratic algorithm completely failed to account for the primal weight of parental rights. And as we peel back the historical layers of how the state legally defines and dissects a child in the modern era, you will discover a terrifying reality about the limits of the law and who actually owns the rights to your family. To uncover this terrifying reality, we must travel back long before the first radio transmission ever echoed through an American living room. In the mid-19th century, the American legal system did not view a child as an emotionally complex human being requiring psychological nurturing. Under the rigid framework of English common law that heavily influenced early United States jurisprudence, children were legally classified in a manner shockingly similar to property. They were considered vital agricultural assets. The family was an economic production unit, and the father, as the absolute head of that unit, held an inherent, almost unassailable property right to the physical labor of his offspring. If a marriage dissolved in the 1850s, there was virtually no legal debate regarding child custody. The father was automatically awarded the children because he owned their economic output. The psychological well-being of the child or the emotional bond with the mother was completely irrelevant to the courts. The law was a crude instrument of economic allocation. This brutal, property-based legal paradigm was eventually shattered by the massive societal shifts of the Industrial Revolution. As the American economy transitioned from agrarian farming to urban manufacturing, fathers left the homestead to work in centralized factories. This geographic shift fundamentally altered the domestic power dynamic. Mothers were left in exclusive control of the home, transforming them from co-laborers in an agricultural enterprise into specialized domestic managers and primary caregivers. To adapt to this new reality, the legal system invented a revolutionary concept known as the tender years doctrine. This legal presumption stated that during a child's formative years, typically defined as under the age of 13, the mother was biologically and inherently uniquely suited to provide the necessary care. The pendulum of legal power swung violently from the absolute right of the father to the absolute presumption of the mother. This is the exact cultural and legal environment that the early broadcast media exploited with absolute precision. When the Hummert radio factories began pumping out serialized soap operas in the 1930s, they were directly targeting this newly defined demographic of isolated, legally empowered, but economically dependent mothers. The radio dramas endlessly reinforced the narrative that the mother was the sacred emotional core of the family unit, and that any threat to her domestic sphere was a catastrophic tragedy. The media and the law were operating in perfect synchronicity. The culture worshipped the maternal bond, and the courts codified that worship into strict legal precedent. For decades, a father seeking custody in an American courtroom was fighting a nearly impossible battle against both legal statutes and an overwhelming cultural bias engineered by the media. However, the legal revolution of the late 20th century, which brought us the no-fault divorce system, completely dismantled this maternal presumption. Just as the legislature decided that assigning moral fault for a broken marriage was inefficient and destructive, appellate courts began to rule that assigning automatic custody based on gender was a violation of equal protection. The legal system required a new framework, a gender-neutral algorithm for dividing a family. They introduced the modern standard, a concept known universally today as the best interests of the child. On paper, it is a beautifully noble concept. It demands that the court ignore the gender of the parents and focus entirely on the safety, health, and welfare of the minor. But in practice, particularly within the unbundled administrative services of the modern era, the implementation of this standard has created a profound psychological nightmare. Let us examine a highly detailed scenario unfolding in the year 2026. Meet James and Olivia, a dual-income couple navigating an administrative, flat-fee divorce in the suburban landscape of the 661 area code. They have a 7-year-old son named Ethan. James and Olivia have successfully utilized a legal document assistant to peacefully divide their home equity and their retirement portfolios. They have behaved rationally and avoided the predatory shadow industry of high-conflict litigation. But now they must divide Ethan. Because the unbundled legal model is strictly administrative, the legal document assistant cannot offer psychological advice or determine who is the better parent. Instead, James and Olivia are handed a standardized state form and told to draft a highly specific parenting plan. They are forced to reduce their child to a mathematical timeshare percentage. This is where the sterile efficiency of modern family law violently collides with human nature. To process the final judgment, the state requires a precise calculation of child support. In 2026, this calculation is entirely removed from human discretion. It is dictated by standardized algorithmic software utilized across the state. This software requires 3 primary inputs to generate a legally binding monthly payment: the gross income of parent A, the gross income of parent B, and the exact physical timeshare percentage the child spends with each parent. Imagine the cognitive dissonance James and Olivia experience in this moment. The legal system has commodified their physical presence in their son's life. The algorithm creates an inherent, deeply perverse financial incentive. If James can secure 50% of the physical custody time instead of 30%, his mandatory monthly child support payment to Olivia will drop drastically. Conversely, if Olivia can restrict James's access to only alternating weekends, her monthly tax-free support yield will increase significantly. The state has inadvertently turned Tuesday nights and holiday weekends into highly lucrative financial commodities. Parents who genuinely want to minimize conflicts suddenly find themselves engaged in aggressive negotiations over a 5% shift in a custody schedule, not because of what is best for the child, but because that 5% shift might represent hundreds of dollars a month in disposable income over the next 11 years. The radio dramas of the past conditioned us to believe that parents fight over children out of overwhelming, desperate love and a desire to protect them from a villainous spouse. But the modern procedural reality reveals that the legal system frequently forces parents to fight over children as a mechanism for financial survival. The algorithmic support calculators have stripped the humanity out of parenting time, reducing the profound responsibility of raising a child to a literal line item on an administrative balance sheet. The legal document assistant simply waits for James and Olivia to agree on the math, input the percentages into the software, and generate the final court order. But what happens when the math completely breaks down? What happens when James and Olivia look at the spreadsheet and absolutely refuse to compromise their time with their son just to satisfy an algorithm? When parents cannot reach a mutual agreement through the unbundled administrative process, the state does not simply let them walk away. The administrative off-ramp closes, and they are immediately forced onto a terrifying new trajectory. If you cannot mathematically agree on how to divide your child, the legal system mandates a psychological intervention. The parents are thrown out of the quiet, predictable world of procedural paperwork and pushed directly into the darkest, most highly subjective, and deeply unregulated sector of the entire family court apparatus. You are about to discover the hidden economy of the child custody evaluation industry. A system where your fundamental constitutional right to raise your own child is handed over to a single, privately contracted stranger armed with psychological testing materials and absolute legal immunity. Imagine if the entire future of your family, your constitutional right to guide the upbringing of your own offspring, and the physical location where your child will sleep every night were suddenly handed over to a single, privately contracted mental health professional. In the golden era of the American radio drama, the overarching fate of the characters was entirely dictated by the writers in the Hummert factory. They decided who suffered, who triumphed, and who was ultimately banished from the narrative. Today, in the year 2026, when parents in jurisdictions like the 661 area code utterly fail to mathematically divide their parenting time through unbundled administrative services, the state court appoints a modern equivalent to those radio scriptwriters. This individual is known as a child custody evaluator, and they serve as the ultimate, heavily compensated director of your real-world family drama. When the sterile algorithm of the state software fails to produce a mutual agreement, the legal system abandons the spreadsheet and aggressively pivots back to deeply subjective, highly performative psychological theater. To understand the sheer gravity of this process, we must execute a step-by-step dissection of how a full child custody evaluation actually functions. This is not a complimentary social service provided by the local municipality. It is a massive, highly privatized, and ruthlessly monetized sector of the family law industry. In California, these professionals are often appointed under Evidence Code Section 730, which designates them as the court's official expert witness. The immediate reality is the financial barrier to entry. Historical trends show that the cost of these evaluations has skyrocketed exponentially over the last 2 decades. In the current year, a comprehensive psychological custody evaluation can easily demand an upfront retainer ranging from $15,000 to $40,000, billed at an hourly rate frequently exceeding $400. If James and Olivia, our case study couple from Santa Clarita, cannot agree on the physical timeshare percentages, they must now liquidate the very savings accounts they just successfully preserved through the unbundled divorce process, simply to afford the person who will sit in judgment of their parenting capabilities. Once the massive financial retainer is deposited, the psychological autopsy of the family officially commences. This is where the echoes of the 1930s radio melodramas become deafeningly loud. The evaluation forces the parents completely out of the peaceful, administrative mindset and shoves them directly back into a fiercely adversarial posture. The first step involves exhaustive clinical interviews. James and Olivia will sit separately in a sterile office while the evaluator relentlessly probes into their deepest insecurities, their childhood traumas, their marital grievances, and their fundamental parenting philosophies. They are forced to construct a compelling narrative, essentially pitching themselves as the superior protagonist in this tragedy, while subtly framing the other parent as the antagonist. The unbundled system told them that fault was legally irrelevant. The custody evaluator tells them that their psychological flaws are the only things that matter. The second step is the administration of standardized psychological testing. The evaluator will subject James and Olivia to grueling diagnostic instruments such as the Minnesota Multiphasic Personality Inventory or the Millen Clinical Multiaxial Inventory. These parents, who simply wanted a quiet administrative separation, are now sitting in a waiting room answering hundreds of true or false questions designed to detect clinical psychopathology, hidden aggression, narcissism, and deceit. The legal system is actively searching for the exact kind of dramatic personality disorders that made the serialized soap operas so overwhelmingly popular with American audiences. They are hunting for narrative conflict. The third step of the evaluation transforms the private dissolution of the marriage into a sprawling public intelligence gathering operation. The evaluator initiates collateral contacts. This means they begin systematically interviewing the child's pediatricians, current school teachers, athletic coaches, neighborhood friends, and individual therapists. The protective bubble of privacy is completely shattered. Every individual who has interacted with the family is now a potential witness in this psychological trial. The evaluator collects these subjective opinions, filtering them through their own personal biases, and compiles them into the growing dossier. The fourth and perhaps most agonizing step is the parent-child observation phase. James will be instructed to bring 7-year-old Ethan to the evaluator's office. They will be placed in a room equipped with toys and instructed to play naturally. The evaluator will sit in the corner with a clipboard, silently observing and grading the interaction. This is the ultimate performative trauma. James is acutely aware that if he corrects Ethan too harshly, he may be labeled authoritarian. If he does not correct him enough, he may be labeled permissive. It is an impossible, highly engineered theatrical performance where the stakes are the permanent loss of his child. Every spontaneous human reaction is instantly pathologized and recorded. When this months-long, agonizing process finally concludes, the evaluator drafts a comprehensive report, frequently spanning 70 to 100 pages. This document is the ultimate script. It synthesizes the clinical interviews, the psychometric testing data, and the collateral interviews into a sweeping authoritative narrative regarding the exact psychological deficits of both parents. And because this document is presented to the court by an officially appointed expert, judges rely heavily upon it. Historical trends and widespread case studies indicate that judges adopt the recommendations of the child custody evaluator in the vast majority of cases. The judge, overwhelmed by a massive docket of hundreds of separating families, gladly defers the agonizing responsibility of dividing a child to the privately paid psychologist. But here is the most terrifying reality of the custody evaluation industry. These private professionals operate under a legal concept known as quasi-judicial immunity. Because they are appointed by the court to assist the judge, they are granted a massive shield against civil liability. If an evaluator makes a catastrophic error in judgment, if their subjective biases lead to a deeply flawed recommendation, or if they rely on debunked psychological theories, the parents have virtually no legal recourse to sue them for malpractice. The state has engineered a system where you are forced to surrender your fundamental parental autonomy to a stranger, pay them tens of thousands of dollars for the privilege, and then absorb the absolute total risk of their potential incompetence. We have traced the evolution of marital dissolution from the performative perjury of the fault-based system, deeply influenced by the dramatic conditioning of early radio broadcasts, to the sterile mathematical algorithms of modern unbundled legal services in the 661 area code. We have seen how the state successfully sanitized the division of assets, only to allow the deeply emotional, highly lucrative theater of adversarial conflict to entirely consume the realm of child custody. The adults in this system are subjected to financial ruin, psychological testing, and algorithmic marginalization. But what happens to the most vulnerable participants in this vast legal machinery? We have analyzed the parents, the attorneys, the legal document assistants, and the private evaluators. However, there is a hidden, massive sociological impact on the exact demographic this entire system theoretically claims to protect. The children raised within these mathematically divided, heavily evaluated, and procedurally processed households are absorbing a completely new type of cultural conditioning. The data emerging from long-term case studies regarding the developmental psychology of American youth navigating this exact system reveals a startling truth. Modern family law is inadvertently rewriting the psychological blueprint of the next generation. creating potential outcomes that no early radio broadcaster or mid-century legal reformer could have ever possibly anticipated. And as we examine the silent collateral damage of this administrative revolution, the true cost of unbundling the American family finally comes into devastating focus. To understand the true magnitude of this collateral damage, we must first recognize that the children of the modern unbundled legal system are experiencing a completely different category of trauma than any generation before them. In the 1930s and 40s, children sat beside their mothers on the living room floor, listening to the agonizing pacing of the Hummert radio dramas. They absorbed the cultural narrative that adult relationships were inherently volatile, emotionally explosive, and defined by clear moral boundaries of right and wrong. When those children grew up and experienced their own marital failures under the fault-based legal system, they possessed a cultural vocabulary for their anger. They fought in courtrooms, they pointed fingers, and they demanded dramatic resolution because that is exactly what the broadcast media had trained them to do. The conflict was loud, it was public, and it was deeply human. But historical trends in developmental psychology reveal a terrifying shift in the 2026 landscape. The children of the modern administrative divorce are not exposed to loud, dramatic courtroom battles. Instead, they are subjected to the silent, suffocating weight of algorithmic bureaucracy. The state has successfully sanitized the process of uncoupling, but in doing so, it has transformed the child from a participant in a family drama into a logistical data point on a state-mandated spreadsheet. To witness the potential outcomes of this sterile environment, imagine a case study involving a 16-year-old girl named Chloe, living right now in the vast suburban sprawl of the 661 area code. Chloe's parents did not hire high-conflict litigators. They utilized the efficient, unbundled services of a legal document assistant to dissolve their marriage. On paper, their divorce is considered a massive success of the modern family law system. They avoided the perjury mills, they bypassed the predatory shadow industry of custody evaluators, and they mathematically divided their assets with clinical precision. But for Chloe, the reality of this mathematical precision is a life defined by relentless, emotionally barren compartmentalization. Her existence is completely governed by the physical timeshare percentage outputted by the state support algorithm. She is a 50-50 custody child, meaning her physical location changes exactly every 7 days. Every Friday at precisely 6 in the evening, Chloe executes a micro-migration. She packs a duffel bag and transitions from her mother's house to her father's apartment. Because her parents have fully embraced the administrative, low-conflict model, they do not argue during these exchanges. In fact, they barely speak at all. They utilize court-approved co-parenting applications, digital platforms designed specifically to filter all communication between separated parents. These applications strip away all tone and emotion, reducing the complex, messy business of raising a human being into a series of stark, text-based logistical updates about dental appointments and extracurricular fees. Chloe lives in a world where her parents interact exclusively through secure digital portals, completely eradicating any spontaneous, organic modeling of adult conflict resolution. The conflict has not disappeared. It has simply been weaponized through silence and administrative distance. This environment breeds a devastating psychological phenomenon unique to the modern era: the parentification of the child through bureaucratic awareness. In the era of the radio drama, the mechanics of a divorce were hidden behind the closed doors of a judge's chamber or a lawyer's office. Today, the unbundled legal system relies on absolute financial transparency. The standardized forms, such as the income and expense declaration, are frequently left on kitchen counters or open on home computer screens. Children like Chloe become acutely, inappropriately aware of the exact financial flow of their divided households. She knows precisely how much child support her father is legally obligated to transfer to her mother on the first of every month. She understands the algorithm. She knows that if she asks to spend more time at her father's house because it is closer to her high school, she will actively decrease her mother's monthly tax-free income, potentially jeopardizing her mother's ability to pay the rent. Imagine if your fundamental choices about where you sleep and which parent you seek comfort from were inherently tied to the financial survival of the other parent. This is not the romanticized, theatrical heartbreak sold by the early broadcast media. This is cold, hard economic anxiety placed squarely on the shoulders of an adolescent. The potential outcomes of this environment are deeply concerning. Longitudinal case studies tracking the emotional development of youths navigating these algorithmic custody schedules indicate a massive rise in hyper-pragmatic, deeply cynical views regarding romantic partnership. The children of the unbundled divorce do not view marriage as a sacred emotional bond, nor do they view it as the passionate, high-stakes drama their great-grandparents listened to on the AM dial. They view marriage entirely through the lens of risk management. When Chloe looks at the concept of a long-term relationship, she does not see a fairy tale. She sees the meticulously organized manila folder of legal documents her parents compiled with their legal document assistant. She sees the marital settlement agreement. She sees the qualified domestic relations order dividing the retirement accounts. The legal system, in its desperate attempt to protect her from the emotional carnage of a traditional courtroom battle, has inadvertently sterilized her capacity for romantic trust. She has been conditioned to believe that love is not a leap of faith, but a highly fragile, temporary arrangement that will inevitably require a mathematical liquidation. The state replaced the emotional trauma of the fault-based divorce with the existential dread of the no-fault algorithm. The historical trends are undeniable. We have engineered a society that attempts to solve deeply human, emotional failures with rigid, unyielding administrative procedures. We have traded the messy vocal anguish of the past for the quiet, predictable, and deeply isolating bureaucracy of the present. The unbundled legal industry, operating in regions like Santa Clarita and expanding rapidly across the United States, is an incredibly efficient machine for processing paperwork. It is a necessary, vital alternative to the predatory, financially ruinous shadow industry of traditional litigation. But it is entirely incapable of processing human grief. It can divide a bank account down to the exact penny, but it cannot explain to a 16-year-old girl why her family was dismantled. This leaves us standing at the edge of a massive cultural and legal precipice. We have traced the entire century-long evolution of the American divorce. We have unmasked the corporate manipulation of early radio broadcasters who intentionally seeded our collective domestic anxiety. We have documented the noble, yet highly destructive legislative rebellion that birthed the no-fault divorce system. We have exposed the deeply predatory litigation complex that rose to monetize our unmet need for narrative closure, and we have analyzed the sterile algorithmic reality of the modern unbundled alternative. The system is vast, it is complex, and it is entirely unforgiving. But the most critical piece of this masterclass still remains. If you find yourself trapped within this machinery in the year 2026, if you are staring down the barrel of a marital dissolution and desperately trying to protect your assets, your children, and your own sanity from both the high-conflict litigators and the cold administrative algorithms, how do you actually survive? What is the precise strategic blueprint for navigating the exact intersection of human emotion and state procedure without losing everything you have ever built? The absolute foundation of this survival blueprint requires a psychological maneuver known in advanced negotiation theory as radical bifurcation. You must violently and permanently sever your emotional reality from your legal reality. For 90 years, the descendants of the Hummert radio factories have broadcasted the insidious lie that your legal process will somehow validate your emotional pain and publicly punish the party who wronged you. You must unlearn this programming immediately. Imagine a man named Robert in the current year of 2026, facing a devastating marital collapse in the sprawling suburban tracts of the Santa Clarita Valley. If Robert walks into an unbundled legal service office seeking a stage to broadcast his heartbreak, he will fail spectacularly. To survive this system, Robert must view the legal document assistant exactly as he views a certified public accountant during corporate tax season. The state court system is not his therapist, the state is not his priest, and the state is absolutely not his vindicator. The modern family law system is merely a bureaucratic machine designed to coldly sever a financial contract. By accepting this brutal, unromantic truth, Robert immediately neutralizes the fundamental psychological vulnerability that the high-conflict litigation industry preys upon. He actively refuses to buy a ticket to his own emotional theater. Once the emotional narrative is successfully isolated, the second phase of the strategic blueprint is aggressive, preemptive financial organization. Historical trends from cases successfully resolved outside the litigation matrix reveal a glaring common denominator. The prepared spouse inherently controls the timeline. Before Robert ever sets foot in the Divorce 661 administrative office, he must act as his own forensic auditor. He does not wait for a hostile opposing attorney to issue a sprawling, terrifying discovery demand. Instead, he proactively compiles a flawless, impenetrable ledger of his entire estate. He gathers 10 years of federal tax returns, he isolates the precise dates of value for every single retirement portfolio, and he tracks the exact monetary lineage of the down payment on the marital home. He organizes this massive trove of data into the exact formats required by the state of California, specifically preparing the meticulous groundwork for the mandatory declaration of disclosure, the schedule of assets and debts, and the income and expense declaration. When Robert finally sits across from the legal document assistant, he does not present a chaotic, emotional mess of grievances. He presents a solved mathematical equation waiting for an official state signature. He completely eliminates the dark, confusing spaces where billable hours traditionally multiply and consume family wealth. But what are the potential outcomes if Robert's spouse is fully indoctrinated by the media conditioning and desperately wants a theatrical battle? What if she hires a highly aggressive litigator to drag Robert by force into the shadow industry of the adversarial courts? The blueprint dictates a strategy of absolute procedural silence and radical compliance. The adversarial system requires a reciprocating combatant to function. It desperately needs the ping-pong effect of angry emails, fiercely contested motions, and defensive posturing to generate its revenue stream. When the aggressive litigator sends a heavily weaponized, threatening legal demand designed specifically to trigger an emotional response, Robert does not react emotionally. He relies entirely on his preemptive financial organization. He responds only with the cold, hard, verifiable data required by the family code. He starves the conflict of its necessary oxygen. Case studies consistently demonstrate that high-conflict attorneys rapidly lose interest in prosecuting a case against a phantom opponent who absolutely refuses to fight and strictly adheres to the mathematical algorithms of the state. The exorbitant legal retainers drain exceptionally quickly when there is no manufactured drama to bill against, inevitably forcing the hostile spouse back to the quiet administrative table out of sheer financial exhaustion. The most critical and psychologically delicate phase of the blueprint, however, involves the protection of the children from the algorithmic bureaucracy we previously exposed. If the unbundled system inadvertently turns children into data points, the survival blueprint requires parents to build an absolute, impenetrable psychological firewall around their offspring. Imagine a mother named Elena, successfully utilizing the flat-fee legal model in 2026, but terrified of parentifying her 10-year-old son. Elena must immediately implement a policy of total informational blackout regarding the mechanical logistics of the separation. The standardized court forms, the algorithmic child support calculation printouts, and the precise physical timeshare percentages must never physically exist in the space the child occupies. Elena must intentionally shield her son from the stark financial realities of his own custody schedule. When the child physically transitions between households, Elena completely masks the logistical transaction with overwhelming, normalized parental warmth. She actively fights the sterilization of the state procedure by manually injecting humanity back into the transition. She ensures that her son never, for a fraction of a second, understands that his physical presence in her home translates directly to a specific tax-free monetary yield on a state-mandated spreadsheet. Even with radical bifurcation and preemptive organization, logistical friction is sometimes inevitable. When a legitimate, non-emotional bottleneck occurs over the highly complex valuation of a shared asset or a specific, granular detail in the holiday parenting plan, the blueprint requires a highly surgical approach to alternative dispute resolution. You absolutely do not return to the high-conflict litigation arena to solve a mathematical disagreement. Instead, you utilize the unbundled methodology to hire a private neutral mediator strictly for that singular isolated issue. You do not grant this legal professional sweeping, omnipotent authority over your entire life. You grant them a 2-hour consultation window to resolve a specific disagreement regarding the division of a stock portfolio or the appraisal of a small business. You keep the ultimate decision-making power entirely within your own administrative grasp, utilizing legal professionals merely as targeted consultants rather than the directors of your family's ultimate fate. To sustain this incredibly disciplined, emotionally detached posture for the 6 to 12 months typically required to process the state paperwork, you must aggressively audit your own cultural consumption. You are actively fighting nearly a century of highly engineered psychological programming. During the entirety of the dissolution process, successful case studies strongly suggest a complete, uncompromising embargo on all broadcast and digital media that commodifies relationship conflict. You must completely stop consuming the reality television shows, the celebrity gossip algorithms, and the serialized streaming dramas that continually reinforce the false narrative of the theatrical breakup. Your brain is highly susceptible to this specific programming during periods of intense domestic instability, By systematically starving your mind of these artificial conflict narratives, you actively deprogram the radio drama legacy from your own psychological baseline, allowing you to operate with the cold, pragmatic clarity required to successfully navigate the procedural reality. By executing this precise, disciplined blueprint, the potential outcomes shift massively in your favor. You successfully traverse the most dangerous predatory legal landscape in modern America without becoming systemic collateral damage. You fiercely preserve the financial foundation you spent decades building, denying the shadow industry the opportunity to liquidate your estate to fund their exorbitant billable hours. You protect the psychological integrity of your children, shielding them from both the terrifying courtroom battles of the past and the cold, algorithmic parentification of the present. You utilize the flat-fee, unbundled administrative services exactly as the legislature originally intended when they enacted no-fault divorce over half a century ago. You achieve your legal freedom not through dramatic, performative vengeance, but through extreme disciplined procedural efficiency. We have completely deconstructed the hidden history of the American marital dissolution, exposing the intricate, invisible web of media manipulation, legislative rebellion, and deeply predatory legal economies. You now possess the absolute masterclass understanding of how the unbundled legal system truly operates behind the curtain in the modern era. But the exact moment the judge's signature dries on your final marital settlement agreement, and you finally believe you are free from the state's overreaching oversight, a completely invisible, highly aggressive corporate surveillance apparatus immediately activates to track your newly separated household. How do massive unregulated data brokers utilize public family court records to fundamentally alter your credit score, dictate your future housing options, and aggressively prey upon your newly single demographic? The reality of the post-divorce corporate data economy is far more terrifying and invasive than the courtroom itself, and we are going to tear that hidden machinery apart piece by piece in our next massive investigation.